All this law does in France is it pretty much just criminalizes speech about medical practices. If you control knowledge, you control thinking. If you control thinking, you control choice. And ultimately, that is what dictators do. But once we get on the path of criminalizing speech and debate, then we are attacking science.
Is France launching a witch hunt against natural health practitioners or even critics of the vaccines? A new French law could send anyone who questions the safety or effectiveness of a drug treatment to prison. After much political wrangling on the 14th of February, the National Assembly, the lower house of the French Parliament, passed legislation which criminalises the act of inciting someone to receive or not to receive medical treatments. Now, this is an important bill that's been hotly contested and it's much talked about. So I've invited David Thunder, who's a political philosopher at the University of Navarra, to come and speak to us about this today. He's recently spent some time in France and he's also written an important article on this on his Substacks. And I think this is David's fourth or maybe fifth visit back to the podcast. So welcome back, David. An important topic for us to cover today.
Yes, indeed. Good to be here and to talk about this topic with you, Dan.
Yeah, so you've written about this, but and you're a fluent French speaker as well, so you've been able to kind of get beneath the bonnet of this issue. Could you tell us in a nutshell what this new French law says, and specifically the contested Article 4, if you may?
Yes, well, the broader law that we're talking about that passed through the National Assembly or the French Parliament, the lower house of the French Parliament, is a law that is targeting what they call sectarian aberrations, so it seems to be something to do with fanaticism and sectarian movements. So you could imagine sects that are, taking advantage of vulnerable people and brainwashing them, and these kinds of images could come into your mind. And so it was a little odd that this would be included under a law that was designed to combat sectarian aberrations. That said, this specific article of the law in question, Article 4, has really drummed up a lot of controversy in France. The media are all over it, and it's been quite vocally criticized by a lot of people in France. It's been all over the media, and the French Council of State, the Conseil d'État, whose job is to advise the French government on laws and on issues to do with the Constitution, has come out and basically criticized this Article 4, saying that it's disproportionate and unnecessary and that it undermines freedom of expression. Now, why would they be so worried about this article? Basically, this article, what it does is it says that if somebody incites another person to forego a treatment or take a treatment that could expose them to serious risks to life or health, that person could be fined 30,000 euros or imprisoned for a year. So that's basically the law in a nutshell. And those treatments that they talk about could be either prophylactic or therapeutic treatments. So they can either be preventive treatments or treatments that are helping to make something better, to make someone better. And I think it's quite broad. The law does not specify exactly what kinds of treatments. It just says pretty much any kind of treatment, either prophylactic or making someone better, therapeutic. And what's specifically very worrying about this law is that it's not targeting medical practice per se. It's not targeting a specific medical intervention. For example, it's actually targeting speech about medical practices. And that's very different.
Yeah, and the other element of the article itself, David, that makes me concerned is this use of the term "in the current state of medical knowledge." So when we're talking about, let's take the vaccines, for example, recently, any online speech that could evaluate the potential effectiveness or safety of a treatment, I mean, could that, within the broad terms, do you think, be utilized to under this law or under this article to fine or imprison someone if someone is saying we do not recommend this vaccine because of these potential implications? Is that a potential application under this law?
Yes, it is. Contrary to some fact checkers we need fact checkers to actually check the fact checkers. But there are a lot of fact checkers out there, self-styled fact checkers, who are saying that it's false to say that critics of mRNA vaccines could be imprisoned under this law. They're denying that that's the case. And they don't provide any evidence to exclude that interpretation, because essentially this law deals with incitement to treatment or non-treatment, right? That could expose the individual in question to serious, let's say, serious risks to their physical health or to their life. And there is one, let's say, condition that might make you wonder, could this apply to vaccines? And that is that it has to be a person who's already sick. Okay. Now, are there people who are already sick who could take a vaccine?
Of course.
Of course. Of
Yes.
course there are.
Yes.
Right. So, and are those people being advised that they need to take the vaccine to protect their life and health? Of course they are. So if somebody comes along and counsels that person that the vaccine is too risky and that they shouldn't be taking it, it's not worth it, that person could be subject to imprisonment for a year or a €30,000 fine. And there's one more condition which could get someone off the hook. And that is that if the person very clearly explains the risks of what they're recommending, lays out those risks and gives full and informed consent to the other person, then they would not fall under this legislation. It would not be a crime. In other words, if there's full transparency regarding the consequences of following my advice, whatever risks are involved, then I wouldn't be subject to this law. But of course, what would that even mean? Does that mean that if someone is worried about the vaccine and says to someone, okay, I think this vaccine could kill you or it could result in serious pathologies. By the way, if you follow my advice, it could be very risky. And if you don't take the vaccine, this could subject to serious risks. So I find that very confusing, that part of the law, because someone who is counseling against a treatment would have a particular interpretation of risk, right? And the official establishment or the medical establishment would have a different interpretation of risk. But there's something you said there that I think is really important, which is that how do we decide what those risks are when they say that, if I subject someone through my advice to a significant risk to their health or their life? According to whom? Who would decide that there's a risk involved? So they say according to the current state of medical knowledge.
But they say that as though that's a fixed body of understanding, which comes back to your point around not only what is that medical knowledge in itself within a vast range of potentialities, and then who determines what is true and fair within such a set of parameters.
Exactly, because the current state of medical knowledge, and the term in the law is the state of medical knowledge, l'état des connaissances médicales, the state of medical knowledge. What is that exactly? Medical knowledge. What is medical knowledge? Medical knowledge is actually something that is ambiguous because it involves competing interpretations. So any body of science, including medicine, involves a kind of an evolution in which gradually a sort of consensus or a quasi-consensus can emerge among scientists about this or that issue. But there are many, many issues that are contested within science and within medicine. And so to simply say, for example, that, well, if there's a risk according to medical knowledge, hang on a second, if there's a risk according to medical knowledge, but the risks of vaccines and other medical treatments are precisely what medical experts are disagreeing about and are arguing over all the time. So, so in that sense, I mean, we saw this with the mRNA vaccines. We saw that when they first came online, when people started taking them at the beginning, many medical experts were saying that they were safe, right? And they were not qualifying those statements carefully. They were saying they're safe. They've been tested, they're safe. But then, evidence started to emerge quite quickly that in fact there were significant harms associated with these vaccines, including elevated risks of myocarditis or inflammation of the heart. And when this kind of evidence was validated by very mainstream scientific authorities, then obviously the message changed, and now almost all medical experts accept that there is a higher risk of heart inflammation for people who take this vaccine. And so that's an evolving state of the medical knowledge, if you want, or the medical thinking, in general. So this kind of law.
So David, under that so here's where, and obviously the harms aren't limited to that, but it hasn't stopped people, quote unquote, the medical establishment inciting people to take that particular intervention. So despite that understanding, we've seen the AstraZeneca product effectively removed from the market, although it is still being deployed in certain parts of the world. So when you've got the medical establishment effectively encouraging, and if you can look back, to me, the medical marketing rules have been followed. I mean, there's a whole discussion itself around the ethics of medical marketing, pharmaceutical marketing. But to my mind, I would say I would want to apply this law to the governments and the pharmaceutical companies themselves for inciting people to take this now that we know that it's harmful. But the general state of medical knowledge doesn't accept that these products are more broadly harmful, and that there is a imbalance of the cost-benefit ratio, so that there are more potential implications, particularly within young, healthy people. So, could the law be? I know that it's not ever going to be applied in that way, that the American authority would be fined, but in theory, could the medical establishment fall foul of this law because they're inciting people to take this experimental therapeutic injection?
Well, if it depends how you interpret the medical knowledge, the state of medical knowledge.
Exactly, which is my point, which is why it's so contestable.
Yeah, so it is contestable, but I think this issue, just like many other issues that we've seen surrounding medicine and medications and the assessment of risk, basically what people seem to be unwilling to accept, a lot of people, including the drafters of this legislation, is that the medical knowledge is inherently contestable. Much medical knowledge is highly contestable, and contestation is the process through which knowledge is purified and refined. And it's only through that contestation that we, let's say, come to have more confidence about certain propositions, certain views about medicine. It's through those views being tested out, being contested, being through experiments over time. And so this law rests on a fundamental misunderstanding about how knowledge works in science and in medicine. Because the state of medical knowledge, in practice, how would they decide what state of medical knowledge is? They'll use proxies. And the proxies they'll use, without a doubt, will be special commissions or special authorities, such as medical regulators, who will tell them what the state of the medical knowledge is. What do we know about medical regulators? They're human beings. They can get things wrong. They're not gods. They have gotten things badly wrong, And people who are eminent authorities, or at least considered as somehow eminent authorities, or at least official authorities, for example, have said categorically that the coronavirus could not have come from a lab. It's highly unlikely to have come from a lab. And then over time, they started changing their tune, and they took another. They admitted, including Fauci himself, admitted that, well, actually, it very well could have come from a lab. What happened in between? Did science move on? It doesn't matter really for what I'm saying. My argument, the only point is that official authorities can get things badly wrong. And so we can't be constantly kind of erecting their opinions as somehow absolutely binding for everybody, because that's the very antithesis of scientific inquiry.
Absolutely. And the other challenge with this, David, for me is that every medical intervention comes with it a set of side effects. But to what degree those side effects are either known, quantifiable, or revealed or disclosed during a point of intervention. So how does the law even discern that a product someone has been incited to take a product that could be dangerous? So, for instance, I've been unwell for the past 6 weeks. I recently I was resorted to, I much favor natural interventions where possible, but I resorted to taking a set of antibiotics. But my recent blood tests have shown that I've got a highly elevated liver function marker, which is an indicator of potential liver damage. Now, I've subsequently discovered that amoxicillin, or a form of penicillin, poses a risk of liver damage. Now, I wasn't advised that by the doctor. Now, it may be in the fine print of the medical information, and that I'm a believer in personal responsibility, so I do hold my hands up to a degree. Although, if I'm publishing this publicly and there's a medical negligence case, then I may have just invalidated it. But my point is this, I suppose, is that to what degree does this then force medical practitioners to have to disclose every single detail? Do we now create a very difficult relationship between the doctor and the patient? And I do think there should be informed consent, but medical interventions are complex. The whole thing is complex. So in order to avoid potential fines, how do you then justify that the intervention poses greater benefit than the harm? But if there is a risk of harm and you've incited someone to take it, is that not problematic under this law?
Yes. I mean, the thing is, I would say that a point made by the Council of State is that there are already existing laws in place to deal with cases of medical negligence, medical fraud, medical damages, and so on. So it's a little strange, this law, in that sense, because it doesn't really cover some kind of a vital necessity. There's already laws to deal with medical misconduct and negligence, and they are rather complex. As you pointed out, even under existing standard laws that are in most jurisdictions about medical, negligence, for example, and misconduct. I mean, if a doctor prescribes a medication and there is a serious risk attached to that medication, the standard practice is that my understanding is that, yes, you can give medications with serious risks attached to them, but that there has to be some proportionality between the benefits and the risks. I mean, if there was no proportionality and, let's say extreme case, there was like 99% chance that this would kill you and a 1% chance it would help you. Presumably that would count as a case of medical negligence to administer a drug like that. And then there's informed consent. If there's a significant risk to the patient of a certain cancer treatment, the patient needs to know that and be informed of it. Since I'm not a lawyer, I don't know how they assess proportionality exactly. But the point is, there's a whole body of legal practices that are devoted to figuring out these complex issues already. And all this law does in France is it pretty much just criminalizes speech about medical practices. And that is why people are up in arms about it. And it follows a pattern we're seeing internationally of criminalizing speech that certain people don't want to be heard. And I'm not saying that every bit of speech is true. Every speech that's legally permissible is true or even responsible. But once we get on the path of criminalizing speech and debate, then we are attacking science, and we're attacking the whole enterprise of science.
I mean, that to me is the overarching concern. We've got into some of the details of the kind of bill itself, but that point here that and because it's so removed from the person actually making, I alluded to my own medical decision recently. Ultimately, I have to take responsibility for my medical decisions. Fair enough, if there was negligence or malpractice on the medical practitioner and they failed to disclose risks, that's a different story. But at some point, irrespective of what the world is saying about a medical treatment, a video that may have influenced your opinion, we're moving so far away from the idea that the individual has any responsibility in their own decision making, and that's a wider problem in society, I think. But what that does then is it puts the onus on those who are the critics of medical treatments, whether it's vaccines or whether it's therapeutics, because I am suspicious of the fact that this is under a sectarian bill. This idea that they're describing kind of natural health as a kind of quackery or some sort of charlatan practice. And I'm not to say that there isn't quackery and charlatanism out there. There certainly is that stuff that's much more difficult to quantify. But as it happens, having found this issue with my liver this morning, I started reading about proven ways to improve the health of your liver. And there are many different studies that verify and validate certain natural protocols to do that. But then I go on the Johns Hopkins website and they invalidate those findings. So on one hand, you've got scientific journals that have created proof points saying that they do work. Yet you've got the medical establishment of Johns Hopkins basically, in no uncertain terms, the language used did dismiss it in a way that you would expect this bill to treat it as a charlatanism. And there are many different alternative therapies. And that, for me, as well, is why I think there's been a lot of, not just around the vaccine story, around free speech around that, because it does challenge our ability to speak freely. But in more broadly, it challenges our ability to explore alternative means of therapy, because all it takes is the medical establishment to say that's quackery or that's, false science or charlatanism. And all of a sudden, there's a problem under this law. Am I correctly interpreting that?
Well, I would say that this law, what it does is it affects people who advocate for those kinds of treatments in particular, right?
Yeah.
Those treatments themselves will be regulated by laws that have to do with things like fraud or medical negligence or medical malpractice, or someone parading as a doctor, but they're not. There could be different ways of dealing with potential problems with people using those treatments. But in general, I believe that if someone has informed consent and if someone explains them a treatment to them and points out any known significant risks attached to that treatment, then that person is free to offer the treatment, and the person should be and the patient should be free to accept it. And so, I mean, ultimately, I think the philosophy behind these sorts of laws, I think you're onto something when you say it has to do with personal responsibility, because the philosophy behind them, I think, is a philosophy of distrust in our ability as citizens and as human beings to take responsible choices about our own healthcare. And the fact is, if someone says that, someone who is not a registered doctor who offers a treatment, that could go wrong, I would say, you know what, you're right, it could go wrong. But then I'd say, so could the treatment offered by a registered doctor.
Absolutely.
It could go badly wrong. And in that case, perhaps even there's a certain extra danger, which is the social trust in that doctor is so high because they're registered that a lot of people would not be questioning their advice. So, I mean, I guess we should be clear that, like, I'm not, I don't think you are either, recommending that people just lightly go and find any person who offers them advice about their health, because our health is so important, obviously, we're not going to take advice lightly. We're going
Absolutely.
to
Agreed.
look into it very carefully and be very conscientious. But I think conscientiously seeking the right kind of advice, for example, the decision to take antibiotics or to seek out another way of dealing with a problem, they are prudential judgments that very often, there's no mathematical formulaic answer to. And citizens should be trusted and patients to work through those issues for themselves, and to seek out whatever counsel they can. And so, yes, so I guess trust is fundamental here. Trust in our own judgments and our ability to work out what's best for our own health.
Yeah, and the reason I go down that path, David, is because that erosion of personal responsibility and trust, to me, creates the space for this kind of ministry of truth that we've kind of spoken about around the kind of, to some degree, illusion of consensus of what the current scientific or medical understanding is. But also then it kind of creates this potential for state science. And my concern about this type of bill is that is the kind of trajectory that it promotes, because, and this has come from my research, many French parliamentarians from the left and right have called for this bill to be either removed or rewritten, presenting arguments on freedom of conscience. We've talked about the protection of whistleblowers and the rejection of this idea of state science, which has come up. We've talked about this idea of the current state of medical knowledge as being a subjective term. But do you think this is this is a overall, and I agree with you on this criminalization of free speech as being a major component here, but is this also a more dystopian trend towards state science? We saw during COVID the science referred to almost like capital S science. Is this part of a broader trend that is occurring in the world of medicine and science that we need to be concerned about?
Yeah, I think that the control of knowledge and the control of science is, you could say that it's there. A certain kind of control is already implicit in the practice of science, insofar as, for example, scientists cannot really figure everything out for themselves, so they rely on shortcuts. And those shortcuts very often are people who have gained some form of recognition or prestige, right? And so rather than reading everything out there, which is impossible, we use shortcuts. I call them epistemic shortcuts. They're knowledge shortcuts. Like, say, finding someone who has a very prestigious career behind them, and we put more weight going in, we put more weight to their conclusions than someone who has, say, no known career in science, or has very little career in science. And that's a kind of informal control, if you want. And then they formalize that in regulators, certain kinds of regulators in for example, in medicine, who decide, what sorts of medications can be put out on the market. But when we get to the point where the state is deciding for us what counts as valid knowledge, that's another step. That's another step towards totalitarianism. I mean, it's because I think it's one thing for us to informally rely on the advice of prestigious individuals, and a very different thing for the state to coercively enforce a certain orthodoxy. I think that's quite different, a certain official orthodoxy. And that is indeed going down a path towards totalitarianism. And I mean, we talk about science. I mean, right now we're talking about science, but presumably the next logical step would be to extend that to other forms of knowledge, maybe economics, maybe generally risk management. There could be other forms of knowledge that could be co-opted by the state and controlled by the state. And so really, this is all about control. It's about, because if you control knowledge, you control thinking. If you control thinking, you control choice. And ultimately, that is what dictators do, isn't it? Authoritarians, they control our choices in one way or another.
Yeah, and you've written about this on your Substack. We've talked about it today, that importance of open debate exchanges about the risks or efficacy of any medical intervention. That process of contestation is actually a critical and essential part of scientific advancement, but also public health protection. In the light of what you've just said about this path towards totalitarianism, what do you think the worst case scenario could be of such repression through a law like this, which effectively is, in a way, criminalizing free speech around medical interventions? What could it ultimately lead to, do you think?
Well, it could ultimately lead to a situation in which state regulators align themselves with certain medical products, and basically consider any criticism of those medical products to be criminal incitement. Especially if, so supposing they have products that are marketed as life-saving products, then if regulators align or are co-opted with, let's say, big pharma, then those regulators could essentially enforce a form of orthodoxy that aligns with big pharma interests, especially if they can sell these products as somehow essential for for sick people not to get sicker, right, or something like that. And that would be only one step, but I'd actually be more worried even about as a precedent, because this kind of law, it establishes the precedent of the criminalization of debates about medicine and about medical treatment. And right now, it's somewhat restricted because it has to be sick people who are, the targets of that speech. But given a precedent like this, they could easily expand it in the future to say anyone, sick or healthy, basically, as long as the medicine is considered officially to be a life-saving medicine in general, then any criticism of that medicine, any attempt to undermine that medicine, that medication, could be viewed as criminal in a future iteration of this law. And so, like any kind of problematic law, including all of the free speech attacks on free speech we're seeing across the world, we should not only be keeping our eyes on what's happening in that specific law, but how that's opening a breach in our legal system for a certain philosophy of regulation, which views speech as treacherous or as dangerous to the public interest, speech that deviates from certain norms. And that's the kind of philosophy that's being introduced. And this is the thin edge of a wedge in which we would be, regulating speech in a much broader manner. And it's by no means scaremongering to say that could be the next development. I mean, look at the hate speech laws in Ireland that already passed through the Parliament and is now before the Senate. You can be arrested under that law for content that is on your computer that you've never published, but that could incite hatred towards this or that group. That's unpublished content, and your house could be raided and you could be imprisoned for having unpublished content in your computer that the government disagrees with or finds could be hateful. I mean, that is totally dystopian. That is 1984 material right there. And that's happening in my country, right across the sea from you.
Gosh, David. I mean, this is a subject actually, as it happens in the last 24 hours, I've come face to face with, because we're actually changing our digital storage solution because Google, we have no protection in terms of what content we store, and our content dealing with controversial matters like this, we know puts us at risk. So we've been looking for digital cloud storage solutions that have full encrypted protection and zero knowledge protection from on the client side, so that the people who hold the material can't actually access it. And even some of the secure platforms like pCloud, they've had things where they've pulled people up on copyright infringements and all kinds of things. So what this means is even broader, because we live in a digital world where even what's not said, it seems, David, it could be criminalized. Now, as with many of these things, this bill seems to have been introduced for the protection of individuals against potential malpractice. But as you are correctly identified, in the medical sense, there is already pre-existing laws that serve this purpose. So to me, it feels like it's more protecting the interests of that current state of medical knowledge and the interests that represent. And to do so requires this criminalization of knowledge exchange, the free exchange of ideas, free speech, which understandably is why people have been up in arms about this, particularly in the context of the vaccination conversation, which is still so important. There's been a lot of continued revelation of harms that has come as a result of that intervention, new understandings of how it works and new pathologies, new understandings of the physiology, the physiological effects, new understanding of the interaction between mRNA and itself and its potential contamination of DNA. All of these things are new emerging states of knowledge. And of course, we don't need to be reminded of the thalidomide cases where under the current state of medical knowledge that was once accepted to be a safe treatment. We now know that not to be true. So to me, this as you said, is a slippery slope. But there has been plenty of contestation of the bill itself. Is there any hope that this will be thrown out or amended? What's the latest on that front?
I don't know if how much opposition there is to it in the Senate. But I hope personally, I hope that they do manage to at least strike out that Article 4. But I wouldn't place bets on it. Let's put it that way, that they will do that any more than that the Irish Senate will strike down this hate speech law. But who knows? Given that it's so controversial in France, maybe we can at least hope that will have some impact on their deliberations. And the fact that this Council of State also came out against it is pretty significant as well. I think that really, they can't say that it's just a bunch of conspiracy theorists now that the Council of State has registered its serious concerns about it.
Yeah, some people on the left and right have come out in support of this as well, which have come out in support of the challenge against it. And as a result, you can't just label it as right-wing conspiracy theorists. The evidence is quite clear that this is a much broader issue. So, David, this has been a fascinating and illuminating conversation on this particular issue. You've written about this on your Substack, and there's also a fascinating set of articles on issues related to this. We'd just like you to take a moment to share where people can read your article and wider work on this subject.
Yeah, my Substack is davidthunder.substack.com. And they can find me on Twitter, David J. Thunder.
Absolutely. And we'll link the specific article and the wider work in the comments of this or in the description of this episode. So, David, thank you once again for being back with us here on our brand new Free Humanity podcast. It's been a delight being with you again. And what a crazy time to be alive and to be witnessing these things. But luckily, we have people like yourselves raising awareness of the core issues at hand. So thanks again.
Thank you. I've enjoyed the conversation.